Good morning, Committee Secretary, and good morning to everyone on the platform. Can we confirm that we have a quorum?
Good morning, Chairperson, and
Recording
everyone
in progress.
on the platform. Chair, we correct, Chair. We have currently 6 members on the platform, Chair. Shall we do a roll call?
Yes, please.
Mr. Mboyani?
Chairperson, good morning. I'm present. Thank you.
Good morning.
Dr. Ntwane?
Good morning, Chair. Good morning, colleagues. I'm present.
Good morning.
Mr. Malamatia?
Morning, Chair. Morning, everybody. I'm present. Thank you.
Good morning.
Mr. Monakedi?
Good morning, Chair. Good morning, colleagues. I am present. Thank you.
Morning.
Mr. Mulder?
Good morning, Chair. Good morning, all. I'm present.
Good morning.
Mr. McPherson?
I'm here. Good morning.
Good morning.
Chair, those are members currently on the platform, Chair. The others may still join us, and I'll keep you posted on that, Chair. Thanks.
Thank you very much. Can we have the agenda, please? Thank you very much. Can we check if there's any apologies, please?
Chair, I've not received any formal apologies, Chair. So I'm assuming members may still will join us as the meeting goes on, Chair.
Okay, so there we have the agenda. Can we have a mover and a seconder for the adoption of this agenda, please? Honorable Malamatia.
Thank you, Chair. I move for the adoption of the agenda.
Thank you very much. Any seconder? Honorable Monakedi.
Thank you, Chair. I second the motion for the adoption of the agenda. Thank you.
Thank you very much. So, members, the purpose of today's meeting is to formally consider the Companies Second Amendment Bill and the Companies Amendment Bill. After the call for submissions, the committee deliberated on considered the inputs received from the public, as well as the inputs from the DTIC and the parliamentary legal advisor on the submissions received. The DTIC and the parliamentary legal advisor also submitted proposed amendments for consideration. After each deliberation and input received from the DTIC and the parliamentary legal advisor, members were requested to take the draft amendments to their respective caucuses for input and to develop party positions in this regard. Parties were requested to submit minority views if they so wish, clearly stating which clause or clauses they did not agree with and the reason for this. And then these submissions from parties would then be captured in the committee report. The committee will now proceed to consider the Companies Second Amendment Bill first, followed by the Companies Amendment Bill. Thank you very much. I'm sure I'm handing over to the parliamentary legal advisor.
Correct,
Yes,
Chair.
Okay.
Margo will share both A list and the B bill of each of each bill, and Ms. Ibrahim will take the committee through that, and the committee will move on each clause. So we will require after each input of Ms. Ibrahim for the committee to move each clause, Chair. Thanks.
Okay. So you need a mover and a seconder for each
That's
clause.
correct. That's correct, Chair.
Okay. Thank you
And
so much.
Thereafter we will adopt the report on the bill.
Thank you so much. Ms. Ibrahim.
Good morning. Thank you, Chairperson, and good morning to all the members and colleagues on the platform. Chairperson, as indicated last week after the committee adopted the draft version of the A list, we then proceeded to ask Creda to put it in the proper format, which is what members now see in front of them. Chair, I won't waste too much of time to rehash what was agreed to last week. I'll try to merely point out where there have been changes between the drafts that were presented last week and the Creda version as you see it on your screens this morning. Just as a reminder, Chair, the committee is expected to adopt the A version, which will then be reflected and translated into the B bill. So the B bill is what you see on the right hand of your screen, and the A list is what you see on the left hand of the screen. And of course, the A list is read together with the introduced bill. Unfortunately, we can't have all of that on the screen at the moment, but these changes have been carried over to the B bill, which is in front of members. Chairperson, starting with clause 1, you will recall that we did an insertion there to just indicate the history of amendments to that particular section. And this was the amendment to section 77, which deals with the time bars for the recovery of lost damages or costs for which someone may be held liable. There were no changes made to this particular section other than those already agreed to by the committee last week. And that was just, as I indicated last week, what we had sought to do there was to make sure that the retrospectivity aspect is clearly captured. So if members are in agreement, Chair, can we please ask that clause 1 then be adopted before I move to clause 2?
Thank you very much, members. Can we have a mover and a seconder for the adoption of clause 1? Members, our day is going to be very long if we struggle to get movers and seconders. Honourable
Mr.
Monakedi.
Monteri?
Chair, I move that we adopt section 1 as presented. Thank you.
Clause 1. Okay. Can we have a seconder? Honourable Ntwani.
Chairperson, I second the adoption of clause 1. Thank you.
Thank you.
Thank you, Chairperson. Moving to clause 2. Chairperson, this was a section that was amending a clause to amend section 162 of the Act, and that was to extend the time bars to declare some...
I'm so sorry to interrupt, but I think procedurally you do need to ask if there are any objections. You did not put that question. It was just whether there was a mover and seconder.
Okay, thank you very much. So let's go back to clause 1. Thank you for that heads up. Honourable McPherson, are there any objections to the adoption of clause 1? No objections. Thank you. May continue. Ms. Ibrahim.
Thank you, Chairperson. Chairperson, clause 2 seeks to amend section 162 of the Act, and specifically the time bars to declare somebody delinquent or to place them under probation. The introduced bill had a period of 60 months, which was an increase from the 24 months, which is in the current Act. So there were no changes to that. The only changes that were made and which were presented last week was to ensure that the retrospectivity was adequately captured. So subsection 2A and 3A, which I did take the committee through last week with the 2 amendments. Nothing further has changed between the draft A list presented last week and the A list on this clause 2 today, Chair. So if members are happy, we can then proceed on voting on clause 2.
Thank you, members. Can we have a mover and a seconder? For clause 2, members. Honourable Ntwani, I see you're unmuted, and Honourable Monakedi, does that indicate that your hands are up?
Yes.
My apologies.
Okay, can we have Honourable Ntwani first?
Chair, I Move for the adoption of clause 2.
Thank you. Please unmute after you've spoken. And then Honorable Monakedi.
Thank you, Chair. I support the proposal that we go along with clause 2. Thank you.
Thank you very much. Please unmute. Honorable Monakedi, thank you. May I ask if there are any objections to the adoption of clause 2? No objections. Please proceed, Ms. Ibrahim.
Thank you, Chairperson. Chairperson, that was the end of what we had presented last week in terms of the draft A-list, but there is something additional that we've now added, and that is an amendment to the long title. Chairperson, the long title had indicated that the bill seeks to amend the time bar for the bringing of an application to declare a person delinquent in terms of section 162, 2 and 3. But that section, Chair, also deals with placing somebody under probation. So all we've done there is to insert or under probation so that it's in keeping with the Principal Act. So it isn't a substantive change. It was merely something that, for whatever reason, was missed in the introduced bill, but it has no bearing on anything of substance, Chair.
But we must still adopt the change.
Yes. So if members are in agreement to adopt the change as reflected in the long title.
Thank you very much. Members, can we have the mover and a seconder for the change to the long title? Members? Honorable Monakedi.
Thank you, Chair. I move that we adopt the changes on the long title as presented. Thank you.
Thank you. Honorable Malamacha.
I second, Chair.
Thank you. So are there any objections to us adopting the change to the long title? No objections. Agreed to. You may proceed, Ms. Ibrahim.
Thank you, Chairperson. Chairperson, then moving on to the memorandum on the objects. Just before that, I just want to remind or take the committee through some very minor changes in the memorandum on objects. Chair, that you will not see in the A-list. Changes to the memo are not typically reflected in the A-list, but they are extremely minor. On page 6, Mark, if you could just scroll down. Yeah, you can stop there. On page 6, in that first line where you see the presidency, in the introduced bill, the letter T for the presidency was capitalized. So we've just merely changed that to make it a small t. And the other thing that we've done lower down on the page, in the footnote, we've changed the citation of the Tungwane case, which is the leading case on the tagging of a bill. So it was correct in the memo, but because paragraph 5.3 cited the case differently to the footnote for consistency, we've just kept it the same. But again, there's nothing substantive in that, Chair. So those are the only two changes that have been made on the memorandum. Thank you, Chair. That brings me to the end of this bill.
Thank you. Members, do we adopt the minor changes in the memorandum?
Chairperson, we can do that for the sake of completion.
Yes. Okay, so we don't have to adopt it.
Okay, no.
Okay. Thank you.
Noted.
I'm guided. Honorable Monakedi and Honorable Malamacha, just lower your hands, please. Thank you. Please proceed, Ms. Ibrahim.
Chair?
Chairperson, the committee secretary will take the committee through the report before we move on to the next bill.
Chair, the committee now must adopt the report, and this is a report before the committee. I shall read it, Chair, if it's okay.
Thank you. Proceed.
The report of the Portfolio Committee on Trade, Industry and Competition on the Company's Second Amendment Bill dated We'll add the date 22nd November 2023. The Portfolio Committee on Trade, Industry and Competition, having considered the subject of the company's second amendment bill, Bill 26 of 2023, National Assembly Second 75 Bill, referred to it and classified by the joint tagging mechanism as a Section 75 Bill, reports as follows. A, purpose of the company's amendment bill. The bill seeks to amend the Companies Act 2008 so as to amend the time bars in respect of proceedings to recover any loss, damages or costs for which a person may be held liable in terms of Section 77 of the Companies Act. The time bar for the bringing of an application to declare a person delinquent in terms of Section 162, brackets 2 and bracket 3 of the Companies Act, and provide for matters connected therewith. B, the process followed by the Committee on the Company's Second Amendment Bill. The bill was introduced to Parliament by the Minister of Trade, Industry and Competition and referred to the committee on the 28th of August 2023. On 29th of August 2023, the committee was briefed by the Department of Trade, Industry and Competition on the bill. On the 1st of September, the committee released a media statement and called for written submissions, with the statement also being placed on all parliamentary social media platforms. On the 4th of September 2023, the committee placed adverts in 1 national, 1 provincial, and 9 regional newspapers, inviting stakeholders and interested parties to submit written submissions on the company's Second Amendment Bill, Bill 2623, the closing date for submission, namely 2nd October 2023. In terms of the rules of Parliament, the committee has a right to approve, reject, or amend any legislation before it. On the 17th, 18th, and 20th of October, the committee held public hearings and invited certain stakeholders to provide oral submission on their submission in respect of the company's Second Amendment Bill. The submissions received from the stakeholders in the bill were not substantive in nature, with the majority of submissions supporting the bill as it gives effect to the recommendation of the Judicial Commission of Inquiry into allegations of state capture, colloquially known as the Zondo Commission. However, the committee received 7 substantive submissions on the bill, namely from the Auditor General of South Africa, Business Unity South Africa, Corruption Watch, Law Society of South Africa, Webber Wentzel, Werksman, and the Western Cape Government. Of these 7, BUSA, Corruption Watch, and LSA form part of the public hearings held on 17th, 18th, and 20th of October. The committee thereafter received briefings from the Parliamentary Legal Services and the DTIC in respect of submissions received before deliberating thereon. The committee agreed to various amendments as depicted in Bill 26A, which are captured in Bill 26B 2023. Chair, the rules allow for minority views. We did not receive any minority views. I don't know if any party would want to move anything, Chair, and this is opportunity for them to do so if they so wish, Chair.
Thank you. Can we check whether any party wishes to raise a minority view? I don't see any hands.
Chair, then we shall proceed, Chair. This will be removed from the report. Then the recommendation will, Chair, if we can go down. The Portfolio Committee on Trade, Industry and Competition.
Okay, just hold on. There's a hand of Ms. Ibrahim.
Chairperson, I don't know if this is the right time, but I just wanted to propose a very minor amendment in keeping with my explanation of the change in the long title, Andre. If we could perhaps just indicate or under probation after delinquent. I think it was in section B, if I'm not mistaken.
Yes, Chair, we'll make that change. Correct. Yes.
Or under probation, that's correct. Yeah. Thank you.
Okay, the change is duly made.
Chair, I'll just read the recommendation and then we will have a move in a second for the adoption of the report. The Portfolio Committee on Trade, Industry and Competition recommends that the House adopts this report and approves the second reading of the company's Second Amendment Bill, Bill 26A of 2023. Thank you, Chair.
Thank you very much. Can we have a move and a second for the adoption of this report on the company's Second Amendment Bill? Honorable Ntwani.
Good morning, Chair. I move for the adoption of this report, Chair.
Thank you very much. Honorable Malamacha.
Thank you, Chair. I stand to second the move of the adoption of this report. Thank you.
Thank you. Are there any objections to the adoption of this report? Honorable McPherson.
Please note the abstention of the Democratic Alliance.
Thank you. The Democratic Alliance abstains. Honorable Mulder.
Honourable Chair, please note the abstention of the FF Plus as well. Thank you.
Thank you very much. No further hands. The report is agreed to. Thank you very much. Can we proceed? I see Ms. Ibrahim, your hand is still up. And
Apologies, Chair, that's a legacy hand.
Okay.
Oh, mine is legal.
Yeah, just lower your hand, please. Thank you so much. Okay. You may proceed, Ms. Ibrahim.
Thank you, Chairperson. We'll be moving to the Companies Amendment Bill, B27 of 2023. I'll take the committee through the A list. I'll just wait for Margot to get it onto our screens.
Chair, we just need to give Margot a couple of minutes, Chair, to do that, Chair.
Yes, you'll take a breather in the meantime.
Okay, thanks.
Are we ready to proceed, Ms. Ibrahim?
Yes, thank you, Chair. Chair, this is Bill B27 of 2023, the A list on your left-hand side and the B bill on your right-hand side. Chairperson, in clause 1, we've made no changes of substance there. The only thing that we've done, members will recall that the definition of treasury regulations was deleted. So there are two very minor things that have been changed on this A list compared to last week, and that's on number 2 and number 4. On number 2, we've omitted the semicolon and we've added a semicolon and, because it was just to show that there's a third definition that was being changed so that it flows properly. And on page 3 in line 16, we've underlined the word or, just to show that that was an insertion and that had, it was a line that referred to shares or debentures, and the word or, because it was inserted, it needed to be underlined. So those were the only changes there, Chair. So if the committee is ready to proceed, they can vote on clause 1.
Thank you very much, committee members. There we have the clause 1. Can we have a move and a second for the adoption of clause 1? Honorable Monakedi.
Thank you, Chair. I think this is as we have discussed and agreed, and I therefore move that we adopt the amendment. Thank you. On clause 1.
Thank you. Can we have a second, Honorable Moatse?
Thank you very much, Chair. I second the move.
Thank you very much. Any objections to the adoption of clause 1? No objections. Honorable members, please lower your hands after you have adopted. So, yeah, that's right. There are no objections. Please proceed, Ms. Ibrahim.
Thank you, Chairperson. Proceeding to clause 2, Chair, there is no changes here compared to the version presented last week, except for the very minor underlining of the word as, where it says as set out in the notice of amendment, and it's underlined now to show that the word as is an insert, is a new insertion. But other than that, there are no changes of substance.
Thank you very much. Can we have a move and a seconder for the adoption of clause 2 as amended? Honorable Moatse.
Chair, I move for adoption of the item as amendment.
Thank you. Is there a seconder for that move?
Dr. Ntwani,
Honorable
Chair.
Ntwane.
Chair, I second the adoption of clause 2.
Thank you very much. Are there any objections to the adoption of clause 2? Honorable McPherson.
Chair, the DA would object to the to clause 2 as it reads, as we believe it should be filed, not receipt. But you can just note our objection. Thank you.
Thank you. Objection noted. Please proceed, Ms. Ibrahim.
Thank you, Chairperson. Chair, there were no proposed changes to clause 3 of the bill, which deals with the Commission publishing the notice filed by the company. But moving to clause 4, Chair, there was also no changes compared to the A list that was presented last week. And clause 4 deals with the right to inspect copies of the annual financial statements.
My apologies, Chair. Should we not vote on clause 3, although there may now be changes in the A bill, but it's part of the bill that was introduced, Chair?
Okay, but it's not listed here in the B bill.
But the bill in totality will the NB must be adopted, Chair. So clause 3, although there's no changes proposed, it must still be adopted.
Okay. Thank you very much, members. Clause 3, the adoption of clause 3 with no amendments. Can we have a mover? Honorable McPherson.
Please note the DA's objection.
Objection noted. Honorable Moatse.
I move for adoption of the clause 3 with no amendment.
Okay. Thank you. Lower your hand after you've spoken, please. Can we have a seconder? Honorable Monakedi.
Again, the proposal to adopt the clause. Thank you.
Thank you very much. So we've noted the objection of the DA, and it's duly, clause 3 is duly adopted. Please lower your hand, Honorable Monakedi. Thank you. Please proceed.
Thank you, Chairperson. Chairperson, on clause 4, it reads exactly as it did in the A-list that was presented last week, except for 2 very minor changes. One is number 5, where it says on page 4 in line 32, before the word opportunity to insert requester and. So previously it read to provide the requester the opportunity to inspect, and now it's changed to provide the requester an opportunity. So that was just a very minor drafting change. It does not affect the substance of the clause at all. And then number 6 on page 4 in line 33, to omit to the person making such request. And we've indicated there the substitution, you'll see in bold square brackets. That's merely done to show that that was deleted from the Principal Act. Again, nothing of substance, it's just a correction on the A-list because we did not capture it correctly last week, Chair. So that's all on clause 4.
Thank you very much. Can we have a mover and a seconder for the adoption of clause 4?
Ms. Moati.
Honorable Martin.
Yes, thank you very much, Chair. I move adoption of the clause.
Into the buckle.
Thank you. Honorable Monakedi.
Chair, thank you very much. I second the proposal to have those minor changes adopted. Thank you.
Thank you. Any objections to the adoption of clause 4? Honorable McPherson.
Chair, please note that he has objection.
Objection noted. Clause 4 duly adopted. Please proceed, Ms. Ibrahim.
Thank you, Chairperson. Moving to clause 5. Chairperson, this was an amendment to section 30, which provided that where remuneration and benefits are received by a director or prescribed officer, that those persons must be named. Committee will recall that you received an external legal opinion and the clause was agreed to. There were no changes made between the A-list that was presented last week in draft form and the A-list that you see before you, Chairperson. Thank you.
Thank you very much. Can we have a mover and a seconder for the adoption of clause 5? Honorable Monakedi.
I so move, Chair. Thank you.
Honorable Ntwani.
Chair, I move for the adoption. Or second the movement.
Thank you.
Thank you.
Any objections? No objections. Agreed to. Clause 6.
Chair, please note that the ACDP will abstain on this on this clause. Thank you.
We note that.
Thank you, Chairperson. I'm moving along to clause 6. Chairperson, this was the clause, a substantive clause that dealt with the remuneration policy and the remuneration report. As indicated last week, Chair, we substantially changed the drafting by splitting the requirements in terms of the policy on the one hand, which is captured in 30A, and then on the remuneration report in 30B, as opposed to the way in which the introduced bill had it, where it was all clumped into one section called 30A at the time. Chairperson, in terms of 30A itself, all we did there was to fix the spelling of the word companies in the heading. So that isn't a substantive change. And then in subsection 2, where it says the remuneration policy M- and it starts with A, must be presented. We had it as a capital M in the A list last week, and we've rectified that and made it a small m. So on that first part, Chair, those would be only really 2 minor changes. On 30B, again, we fixed the spelling of the word companies. just to indicate that it needed a apostrophe S. The definitions all stayed the same as presented last week, being total remuneration, employee, and committee. Subsection 2 also stayed exactly the same. On subsection 3, where it says the remuneration report must consist of the following parts, we made a very minor change, Chair. In the introduced bill, it read the remuneration report must consist of the following separate parts, and the content advisor correctly pointed out that that was tautologous, that where you speak of parts, you don't have to indicate that they're separate parts, so the word separate has been deleted there, so you'll see that now on the A list. Chair, the rest of that, subsection 3, remained the same. That is the section that's dealing with the payment wage gaps. Members will recall we had some discussion of whether to include the gender pay gap over there, but there was consensus, or at least a majority view, that it shouldn't be included, so there were no changes made there. However, Chair, on subsection 4, we've changed the drafting compared to what was presented last week. This is the subsection that deals with the two-strike rule, and the drafting was amended in consultation with the department and Professor Katz, just in order to make it more clear. So, Chair, if you'll allow me, I'm going to read subsection 4, because as I've indicated, it's slightly different to what was presented last week, but it isn't, the changes aren't substantive in nature, and that the policy remains exactly as it was last week. So if I start at subsection 4, Margot, if at the annual general meeting, the remuneration report is not approved by ordinary resolution as contemplated in subsection 2, A, the committee must, at the next annual general meeting, present an explanation on the manner in which the shareholders' concerns have been taken into account. And B, subject to subsection 6, the directors who are not involved in the day-to-day management of the business of the company and who serve on the committee must stand for re-election as members of the committee at the annual general meeting at which the explanation is presented. Subsection 5, subject to subsection 6, if at the annual general meeting in the year immediately following the year contemplated in subsection 4, that would be the year where the explanation is provided, the remuneration report in respect of the previous financial year is also not approved by ordinary resolution of shareholders, then A, the directors who are not involved in the day-to-day management of the business of the company and who serve on the committee may continue to serve as directors, provided they successfully stand for re-election at that annual general meeting. And B, will not be eligible to serve on the committee for a period of 2 years thereafter. Chair, we did have discussions with the department on the drafting of paragraph B, the one that reads will not be eligible to serve on the committee for a period of 2 years thereafter. We initially made reference to the annual general meeting as contemplated in 4B, but we just thought that it creates some confusion, and this drafting is clearer. So that is something that I myself, as the parliamentary legal advisor, is proposing. So, Chairperson, those are the changes, subsection 4 and 5, but the committee would have to adopt this clause in its entirety, consisting of both 30A and 30B, those insertions. Thank you, Chair.
Thank you very much. Members, can we have a move and a seconder? Is this clause 6? If you can just go down so that you can see the clause.
That's correct. That's correct. It's clause 6.
Okay. Can we have a mover and a seconder for the adoption of clause 6?
Chair, sorry, just a point of clarity, Chair.
Yes.
Chair, in this particular clause, does it also include, despite that's the two-strike rule that we just discussed now, but it also includes the gender pay gap as well, and so that presents a little bit of a difficulty, because the strike 2 clause for the ACDP, we would agree with, but if we're looking at the entire clause and it also includes the gender parity, we actually do believe that there ought to be the inclusion of gender parity as well within the clause. So I'm just wanting to know whether this particular clause, when we accept it, it includes those two aspects.
The legal advisor did explain. I'll just ask her to repeat.
Thank you, Chairperson. So no, it does not include the gender pay gap, but what the member can do is we can ask the committee secretary to record it as an approval of the clause. However, we reject the fact that the gender pay gap was not included. Alternatively, Chair, the gender pay gap was one of those issues that we indicated would require further public participation. So there's nothing preventing the committee secretary from capturing it in a separate section. So not in terms of this clause itself, but that a particular party rejects the fact that this matter, which had arisen in public participation, was not included in the bill.
Thank you very much. Honourable McPherson.
Yeah, thanks, Chair. I think that Ms. Ibrahim has also guided us on this, because I do think that when there is the minority section of this is written, I think it is very clear that certainly the DA and other parties like the ACDP and I think the Freedom Front Plus as well were very vocal on the issue of the gender pay gap matter, which is not recorded in here. So I think if Andre can take a note of that, that would form part of the minority report, at least that we would subscribe ourselves to as the DA. But then obviously we then need to decide on how to vote on this clause, considering that that matter is not there. So maybe that takes care of the one matter, and then we just simply need to decide on a way forward for this clause. Thanks, Chair.
I think Ms. Ibrahim has given us a proposal how it can be captured.
Chair, just to in support of that, we will, as part of a minority views, it will be captured, Chair. So at the end of this process, we will just break for about 10-15 minutes to capture these minority views and submit the report for the committee to adopt, Chair.
Thank you very much. So can we have a mover and a seconder for the adoption of Clause 6? Honourable Monakedi.
Chair, I move that we adopt Clause 6 as presented. Thank you.
Thank you very much. Can we have a seconder? Honourable Monakedi, please mute. Can we have a seconder for that proposal to adopt Clause 6? Honourable members, can we have a seconder for the adoption of Clause 6?
Thank you very much. I propose that we adopt. I second the adoption of Clause 6. Thank you.
Thank you very much. Are there any objections to the adoption of Clause 6? Honourable McPherson.
Chair, please note the abstention of the DA for Clause 6. Thank you.
Thank you very much. Honourable Mulder.
Thank you, Chair. Abstention from Clause 6 FF Plus as well.
Thank you very much.
And the abstention of the ACDP, Chair.
And ACDP. Thank you very much.
Chair and the ACDP, thank you.
Yes, I did. I think you must be in more than one meeting. We did note your abstention. Thank you very much. So Clause 6 is duly agreed to with those abstentions. And we'll move to Clause 7. Ms. Ibrahim.
Apologies, Chairperson, I'm on mute.
Okay.
Chairperson, Clause 7 propose an amendment to Section 33 of the Act, which required public companies, state-owned companies, and companies with a public interest score above the threshold to file together with their annual returns a copy of their latest annual financial statements. The clause as presented last week has remained the same. This week there are no further changes, Chairperson. Thank you.
Thank you. Can we have a move?
Chairperson, apologies. Sorry, Chairperson, apologies. There is one very minor change. On page 6 in line 12 of the bill, to refer to regulations as contemplated in, and we've just deleted the as contemplated and made it regulations contemplated in. That's in keeping with drafting in the rest of the Act. But again, Chair, it's nothing substantive from last week. Thank you.
Thank you. Can we have a move and a seconder for the adoption of Clause 7? Honorable Ntwane.
Good morning, Chair. I move for the second adoption of the Clause 7, please.
Thank you. Honorable Monakedi.
I second the motion to have Clause 7 adopted. Thank you.
Thank you. Any objections? No objections. Agreed to. Honorable Monakedi, can you mute, please?
My apology.
Clause 8.
Thank you, Chairperson. Chair, the committee made no proposals in respect of Clause 8. If you'll recall, that dealt with empowering a court to validate the creation, allotment, or issue of shares. And there were no changes in there, which is why you do not see it on the A list.
Thank you very much. But can we have a mover and a seconder for the adoption of Clause 8? Honorable Monakedi.
I shall move, Chair, that we adopt Clause 8. Thank you.
Thank you. Honorable Ntwane.
I second the mover, Chair.
Thank you very much. Any objections to Clause 8? None. Agreed to. Clause 9.
Thank you, Chairperson. Chairperson, Clause 9, there have been no changes to what was presented last week. This was the clause which required partly paid shares to be transferred to a stakeholder. Members will recall they agreed that we should insert that the stakeholder be an independent stakeholder instead of a trusted stakeholder, and that the stakeholder agreement be a written agreement. But this is exactly as was presented and agreed to last week, Chair. Thank you.
Thank you. Can we have a mover and a seconder for Clause 9? Honorable Monakedi.
I move that we adopt Clause 9, Chair. Thank you.
Thank you very much. A seconder. Can we have a seconder to the adoption? The Honorable Ntwane.
Chair, I second the adoption of the Clause 9.
Thank you very much. Are there any
Chair, my
objections?
apologies. Chair, my apologies. Just before we move from this, the ACDP doesn't have an objection, but I'm just looking at Clause 9, the comparison between the A and the B list that we have. It says on page 6 in line 47 to omit a trusted and substitute with an independent. So I'm looking at where line 47 actually is. And I think, I'm not able to find that where line 47 actually is. I can see 45, 46, and then 47 would actually possibly be that the title amendment section 45 Act of 2008. So I'm not sure whether there's an alignment of what is actually there.
Wow, you have eagle eyes, Ms. Ibrahim.
No, Chairperson, it won't align. The reason being is that the A list, the line numbers refer to the lines as per the introduced bill. Because what you would do is you read the introduced bill together with the A list. And when you put those two together, Chair, you create the B bill, which is on the right-hand side of Margot's screen. So if the member would like to read exactly where the change would be, the easiest thing to do is to take the introduced bill and then read the line numbers as per the A list that's in front of you. It is a little bit confusing, Chair. Ideally, you would want to be sitting with 3 documents in front of you so that you can
Chair.
follow.
Understood, Chair. Thank you.
Thank you. May I ask if there are any objections to us adopting Clause 9? No objections. Agreed to. Clause 10.
Chairperson, I'll deal with Clause 10, 11, and 12 together. The committee do not propose any changes to those clauses, but by way of reminder, Clause 10 proposed an amendment to Section 45, and that dealt with excluding the provisions of that section from applying to the giving of financial assistance by a holding company to its subsidiary. Members will recall that there was some input in public participations as to whether that could include international subsidiaries or not, but there were no changes made there at all, which is why it's not reflecting. And then on Clause 11, that proposed an amendment to Section 48 of the Act, that a special resolution will not be required when a company is implementing a share buyback by means of an offer made pro rata to all shareholders. There were no changes there. And Clause 12 proposed amendments to Section 61 of the Principal Act that dealt with the appointment of the Social and Ethics Committee at the AGM and requiring that committee report and remuneration report to be presented at the AGM. But there were no changes to those 3 clauses, Chair. Thank you.
Thank you very much. So can we have a move and a seconder for the adoption of Clause 10, 11, and 12, please? Members? Honorable Dr. Ntwane.
Okay, I move for the adoption of sections 10, 11, and 12.
Clause 10, 11, and 12. Honorable Monakedi.
I second the proposal. Thank you very much.
Thank you. Can I check whether there are any objections?
Thank you, Chairperson. Chairperson, Clause 13 also deals with the Social and Ethics Committee, and particularly when one can apply for an exemption to that requirement to have a Social and Ethics Committee. The clause remains exactly as it was presented last week, which was just minor rewording. There's been no changes in what was presented, Chair. Thank you.
Very much. Can we have a mover and a seconder for the adoption of Clause 13? Honorable Monakedi.
Thank you, Chair. I move that we adopt Clause 13. Thank you.
Thank you. Can we have a seconder for that move? Honorable Dr. Ntwane.
Chair, I second the adoption, the mover for adoption of the Clause 13.
Thank you. Can I check if there are any objections? Honorable McPherson.
Chair, please note the objection of the DA, and specifically the onerous requirement on a Social and Ethics Committee for any other company is the problem, in that it creates an intolerable burden on small businesses to comply with such. So if that can just also be added to the minority report. Thank you.
Thank you. No minority report. It will be minority reviews that will be captured. Honorable Mulder.
Thank you, Honourable Chair. The Freedom Front Plus would also support, in this instance, the DA, and note our objection to that specific clause. Thank you.
Thank you.
Chair, the ACDP will abstain on this one. Thank you.
Thank you. Noted. Agreed to. Clause 14.
Thank you, Chairperson. There are no changes proposed to clause 14. Members will recall there was a very minor amendment that we proposed last week, which was to change the word section to sections, because it had referred to section 34.2 and 84.1. So it was just to pluralize that word. So that's it for clause 14, Chair. Thank you.
Thank you very much. Can we have a move and a seconder for the adoption of clause 14? Honorable Monakedi.
Thank you, Chair. I move that we adopt clause 14, Chair.
Thank you. Can we have a seconder? Honorable Mbuyani. Honorable Mbuyani, we can't hear you. Can we have another seconder for that mover for the adoption of clause 14? Honorable members, can we have another? Honorable Ntwani.
Chair, I second the adoption of clause 14.
Thank you. Are there any objections to the adoption of clause 14? No objections. Agreed to. So I take it we deal with 15, 16, 17, and 18 together. Ms. Ibrahim.
Thank you, Chairperson. Chairperson, there were no changes proposed to those clauses. If you'd like, I can remind members as to what the content of those 4 clauses were. But there is nothing in the A list. There were no proposals at all in respect of those clauses.
Thank you. Members, can we have movers and seconders for the adoption of those 4 clauses? Unless you want the legal advisor to go through it. Dr. Ntwani?
Chair, I move for the adoption of those 4 clauses.
Thank you. Honorable Monakedi?
Chair, I second the motion by Dr. Ndwani. Thank you.
Thank you. Any objections? No objections. Agreed to. Clause 19.
Thank you, Chairperson. Chairperson, clause 19, members will recall there was a typo in the introduced bill. It said B instead of by. That was as presented last week. And the only other change we've made, Chair, is that we've deleted a comma that we thought was unnecessary on page 11 in line 11, but it has no substantive consequences at all.
Thank you. Can we have a mover and a seconder for the adoption of clause 19? Honorable Ntwani?
Chair, I move for the adoption of clause 19.
Thank you. Honorable Monakedi?
I second that we adopt clause 19, Chair. Thank you.
Thank you. Are there any objections to adoption of clause 19? Honorable Malamacha? I see you dropped your hand. So you must please move to a spot where your network is better. We can't hear what you're saying, Honorable Malamacha. There are no objections. Agreed to. Clause 20.
Chairperson, clause 20, there were no proposed amendments to. That clause just had consequential amendments and it deleted certain obsolete provisions in section 167.1, but there were no proposals to amend anything in that section, which is why we don't see it on the A list.
Thank you very much. Can we have a mover and a seconder for the adoption of clause 20? Honorable Ntwani?
Chair, I move for the adoption of clause 20.
Thank you. Honorable Malamacha.
Thank you, Chair. I second the move.
Thank you. Your network is perfect. Can we check whether there are any objections to the adoption of clause 20? No objections. Agreed to. Clause 21.
Thank you, Chairperson. On clause 21, there are no amendments other than that which was proposed and agreed to last week, where we omitted Treasury regulations and substituted it with its regulations. Members will recall that we deleted that definition of Treasury regulations because it was unnecessary. Thank you, Chair.
Thank you very much. Can we have a move and a seconder for the adoption of clause 21? Honorable Monakedi.
Thank you, Chair. I move that we adopt the minor changes as explained in clause 21. Thank you.
Thank you, Honorable Monakedi. Can we have a seconder? Honorable Ntwane.
Chair, I second the move, the move to adopt the clause.
Thank you very much. Honorable Malamacha.
It was to second, Chair.
Okay, thank you. Any objection to the adoption of clause 21? No objections. Agreed to. Clause 22.
Thank you, Chairperson. Chairperson, there were no proposed amendments to clause 22. That was the clause that sought to empower the tribunal to conciliate, arbitrate, or adjudicate administrative matters affecting a company in terms of the Act.
Thank you. Can we have a move and a seconder for the adoption of clause 22? Honorable Malamacha.
Thank you, Chair. I move for the adoption of clause 22.
Thank you very much. Can we have a seconder for clause 22? Honorable Monakedi.
Chair, I second the proposal. Thank you.
Thank you very much. Any objections to the adoption of clause 22? No objections. Agreed to. Clause 23.
Thank you, Chair. Chair, clause 23 sought to empower the Financial Reporting Standards Council to issue financial reporting pronouncements. We've just inserted the word "the" before Financial Reporting Standards Council. That is how it was in the Principal Act, but it wasn't carried through in the introduced amendment bill. And then, Chair, we've made a very minor change. There is a part that reads the relevant information, and we've changed that to say any relevant information, as opposed to the relevant information. Other than that, Chair, is exactly as was presented last week.
Thank you. Can we adopt clause, have a move and a second for the adoption of clause 23? Honorable Ntwane.
Chair, I move for the adoption of clause 23.
Thank you. Honorable Monakedi.
I support, Chair. Thank you.
Thank you. Any objections? No objections. Agreed to. Clause 24.
Thank you, Chairperson. Chairperson, clause 24 merely seeks to indicate what the arrangement of sections will be. Of course, there's a new 30A and 30B, so that would have had to be shown so that when the Principal Act is amended, that those sections can be included under the arrangement of sections at the beginning of the Act. And the only thing we changed there last week that's different from last week, Chair, is that we've corrected the spelling of the word companies.
Can we have a move and a second for the adoption of clause 24? Honorable Ntwani.
Chair, I move for the adoption of clause 24.
Thank you. Can we have a seconder? Honorable Malamacha.
I second, Chair.
Thank you very much. Any objections? No objections. Agreed to. Clause is the next one, clause 25.
Yeah, no, there's nothing else, Chair. That brings us to the end of the A list.
Thank you. So we'll deal with the report now.
Chair, before we do
Chair?
that, I can just take the apologies, Chair. If I can just take the committees through the memorandum on the objects.
Yes.
Chair, in paragraph 2, clause by clause description of the bill. Chair, over there where it says clause 1 inserts the definition of triple BEE Act and triple BEE Commission. And it also refers to Treasury regulations. That has to be deleted because, of course, we've taken Treasury regulations out of the B bill. And then the only other change we made, Chair, is in 2.6, whereas the original memo noted the insertion of section 30A, because we've split that section, we've now just indicated that we've inserted sections 30A and B. Other than that, Chair, there were no changes to the memo. Thank you.
Thank you. Can we have a move and a second for the adoption of the memorandum? Honorable Monakedi.
I had proposed that we adopt the memorandum. Thank you.
Thank you. Can we have a seconder? Honorable Malamacha.
I second, Comrade Chair, Honorable Chair.
Thank you. Any objections? No objections. Agreed to. Committee Secretary.
Chair, we will now request that we were given half an hour just to, before we look at the report, to capture the minority views as reflected in the meeting, Chair. Chair, objections and abstentions will be noted in the minutes. Where minority views were expressed was in clause 2, specifically from the Democratic Alliance, clause 6 from the Democratic Alliance and the Freedom from Plus, clause 13 from the Democratic Alliance and the Freedom from Plus, Chair, just allow us to capture those matters, Chair, and then we will come back to and give us half an hour, and then we will reconvene, Chair, if that's in order with the committee, Chair, so that we can capture that in the committee. And I think the ANC also wish to indicate their view on the gender pay gap, so we need to formulate that as well, Chair. Thanks.
Thank you very much.
Chair, my apologies, Chair.
Yes.
I did not hear the committee secretary indicate the ACDP's concerns with regards to the gender pay gap. I think he only mentioned DA and Freedom Front Plus. Remember that the ACDP raised the matter, yes, and then was followed by the DA and then the Freedom Front Plus. So just apologies for that to be captured correctly. Thank you, Chair.
I think let us not go into that at the moment, and we'll see when the report comes if there are any omissions, because I think the committee secretary was just giving a helicopter view. So can we then reconvene at 10:45?
Correct, Chair.
Thank you very much. We'll break until 10:45. Members, please be back on the platform, or please don't leave the platform, and we'll see you at 11:15. Thank you. Thank you very much, members. We are ready to resume our meeting. Committee Secretary, over to you.
Thank you, Chair. I will just ask Margaret to flag, Chair. Chair, remember, we have submitted these reports to members and asked for their input, and we received inputs from the ANC in that regard as well, Chair. But let me proceed with the report, Chair. The report of the Portfolio Committee on Trade, Industry and Competition on the Companies Amendment Bill dated 22nd of November 2023. The Portfolio Committee on Trade, Industry and Competition, having considered the subject of the Companies Amendment Bill, Bill 27/2023, National Assembly Section 75 Bill, referred to it and classified by the joint tagging mechanism as a Section 75 Bill, reports as follows. Purpose of the Companies Amendment Bill. The bill seeks to amend the Companies Act 2008 so as to inter alia amend the definitions of securities, insert new definitions, clarify when a notice of amendment of memorandum of incorporation takes effect, differentiate where the right to gain access to companies' records may be limited, provide for the preparation, presentation, and voting on a company's remuneration policy and its remuneration report, provide for the filing of a copy of the annual financial statement, empower the court to validate the irregular creation, allotment, or issue of shares, clarify how shares which are not fully paid are to be dealt with, exclude the subsidiary company from the requirements relating to financial assistance, provide for instances where a special resolution is required for acquisition of shares by the company, extend the definition of an employee share scheme to include situations where there are purchases of shares of a company, provide for the circumstances under which a private company will be a regulated company, to deal with the composition of the Social and Ethics Committee, provide for the publication of the application for exemption from the requirement to appoint a Social and Ethics Committee, provide for the presentation of the Social and Ethics Committee's report at the annual general meeting or shareholders meeting as the case may be, ensure the differentiation of duties between the chairperson of the company's tribunal and the chief operating officer, and provide for matters connected therewith. The process followed by the Committee on the Companies Amendment Bill. The bill was introduced to Parliament by the Minister of Trade, Industry and Competition and referred to the committee on the 28th of August 2023. On the 29th of August, the committee was briefed by the Department of Trade, Industry and Competition on the bill. On 1st September, the committee released a media statement and called for written submissions, with the statement also being placed on all parliamentary social media platforms. On the 4th of September 2023, the committee placed adverts in 1 national, 1 provincial, and 9 regional newspapers, inviting stakeholders and interested parties to submit written submission on the Companies Amendment Bill by the closing date for submissions, namely 2nd October 2023. The committee received 40 substantive submissions. In this regard, in terms of the rules of Parliament, the committee has the right to approve, reject, or amend any legislation before it. On the 17th, 18th, and 20th of October, the committee held public hearings and invited certain stakeholders to provide an oral presentation on their submission in respect of the Companies Amendment Bill. The committee thereafter received briefings from the Parliamentary Legal Services and the DTIC in respect of submissions received before deliberating thereon. The committee agreed to various amendments as depicted in Bill 27A, which are captured in Bill 27B 2023. With regard to the inclusion of a gender With regard to the inclusion of the gender pay gap ratio in subsection 30B3, the African National Congress was of the view that while the gender pay gap ratio was an important aspect of remuneration equality, its inclusion would require in-depth consideration and public participation. Therefore, we propose that this be considered in the next Parliament. Minority views expressed on the following aspects contained in this report. Clause 2, the Democratic Alliance was of the view that the word filing was more appropriate than receipt. With respect to Clause 6, the Democratic Alliance, the Freedom Front Plus, and the African Christian Democratic Party were of the view that the gender pay gap as raised by stakeholders should have been included in the remuneration report subsection 30B brackets 3 close brackets. Clause 13, the DA and the Freedom Front Plus rejected the clause as they were of the view that this would create an undue administrative burden on smaller companies. Recommendation. The Portfolio Committee on Trade, Industry and Competition recommends that the House adopts this report and approve the second reading on the Companies Amendment Bill 27A of 2023. Thank you, Chair.
Thank you very much, Committee Secretary. Can we now have a move and a seconder for the adoption of this report? Honorable Mbuyane.
Chairperson, thank you very much for the opportunity. I move that the report be adopted as a true reflection of our deliberation on the bill. Thank you very much.
Thank you very much, Honorable Mbuyane. Honorable Malamacha.
Thank you, Chair. I stand to second the move of the adoption of the report. Thank you.
Thank you very much. Are there any objections to the adoption of the report? Honorable McPherson.
Please note the abstention of the Democratic Alliance.
Thank you very much. Honorable Mulder.
Thank you, Honorable Chair. The FF Plus will have to abstain as well.
Thank you.
Chair, as well as the abstention of the ACDP. Thank you.
Thank you. So with those abstentions noted, the report is agreed to. I think, does that conclude our meeting, Committee Secretary, or are there any
Chair,
other?
that would conclude the business of the day, Chair. If I just may speak to next week's meeting, if through
yes,
you, Chair.
Please. Yes.
Chair, just to remind members that next week's meeting will be in person.
Sorry, Chair.
Yes,
Sorry, Chair, my hand is up. I just want to...
Oh, sorry, I didn't see that.
Yeah, thanks, Chair. Just, do we know when this will be sent to be ATC'd, and when it is likely that this will go to the House for consideration? Thanks.
Okay, let us check with the Committee Secretary if you have any indication on those two, when it will be ATC'd and when it will serve in the House.
Chair, we will just make the corrections to the bills, Chair, and the report can be ATC this evening. Today, Chair, the House matter is a programming committee matter. I think that the parties must speak to the particular party whips in the programming committee to facilitate the setting up of a date in the House, Chair. We're not privy to that process.
Yes,
Chair.
of course.
Thanks.
Okay then. Thank you very much. You may proceed, Mr. Emmons.
Chair, just to remind members that next week's meeting is in person. We will meet in S12A and we'll meet with the SIU on the 28th of November, and we will meet on the virtual platform, the NPA, on the 5th of December, Chair. Thanks. Those are the last two meetings that we have scheduled for the committee.
Thank you very much. See you in person in Parliament next week, members. The meeting stands adjourned.
Thank you, Chair.
Long live the chair.
Long live the Chair.
Thank you, Chair.
I think you must remove Honorable Moatse. She's in a meeting.